Welcome to Immigration Uncovered, the DocketWise video podcast, where we dive deep into the dynamic world of immigration law. I'm James Pittman, co-founder of DocketWise. This is episode 39, and I'm very pleased to be joined today by Jeff Joseph. He is the AILA president-elect, who will begin his term in June 2025 as president of AILA. He's also a partner at Barry Appelman and Layden law firm. Jeff, welcome.
Thanks, James. I'm happy to be here and I appreciate the invitation.
Yeah, so today we're going to be talking about what it means to be a great immigration lawyer in terms of achieving outstanding outcomes for your clients. So it's been a theme that I've been exploring in a couple of episodes, and today we're going to be talking about achieving outstanding outcomes. So Jeff, before we get into that, can you share what initially inspired you to get involved in immigration law and what keeps you motivated to practice in this field?
Sure. So, it was a bit of happenstance. I wanted to be a human rights lawyer, and my grades were not good enough to get into Georgetown or Columbia or the schools that have amazing human rights programs. But I did find my way at University of Denver and took a lot of human rights courses and ended up in a clerkship that was at the Center for Human Rights Advocacy. And it ended up being exclusively refugee and asylum cases and almost exclusively from the former Soviet Union. So a lot of Orthodox Christians, Orthodox Jews, a lot of gay cases. And it was great. I loved it. I loved the work. It was super interesting, but it was a lot of the same thing over and over again. It was a lot of the same stories. So I pivoted and was going to work for the public defender's office. I was clerking for the public defender's office my last 2 years of law school. And then shortly before graduation in March, a good friend of mine, his mother is an immigration lawyer, and he said she's hiring, and I know you've done a little bit. You should apply for a job. And so I did. I applied for a job doing corporate immigration, but I brought a trial skill set with me and Spanish fluency. So I asked her if I could build a little removal defense practice within her practice, and she said, of course. And so I did that. And in December of 1998, after working for her for about a year and a half, I took those removal practice clients and family clients and started my own firm in December of 1998. That's kind of how I got started, and I've been doing it ever since. I ran my own practice with my wife, Kirby Joseph, who's also an immigration lawyer, for 25 years. And then 4 years ago, I got recruited by Barry Appelman Leiden to start a Denver office. Barry Appelman Leiden is a global corporate immigration firm. And so I'm doing mostly large scale corporate immigration now.
Well, very interesting. It's an interesting path, and it shows you. It goes to show you, that the paths are many, right? You're someone who started with interest in human rights and asylum, and it evolved into a general expertise in immigration law that you're now applying in a business immigration context. So the paths are many. So, let's talk a little bit about achieving outstanding outcomes for clients, which is today's topic. So in your opinion, what does it mean to be a great immigration lawyer as opposed to just an immigration lawyer?
I think that's a fantastic question. And, I think there are certain things that we all do, right? So we all fill out forms. We all gather supporting documents for our clients. We submit those to the government. And so there's certain things that are sort of standard across from lawyer to lawyer. And so I always think about, what distinguishes me from the person right down the hall who's doing the same job that I am. To me, it's the customer service component of it. It's the empathy component because, the forms to me is the easy part. And frankly, in this environment and where we're going to the future, that's likely to be replaced by robots and automated. And so that part of what we do is really, to me, the least valuable part of what we do. The most valuable part of what we do is holding someone's hand through that process. Because for the foreign nationals going through this process, whether it's a business process or a family process or removal defense, it is one of the most significant events of their life. And so being there with them, not just as a forms processor, but as a human being with empathy and guiding them through that process, to me, is what establishes a great lawyer from an average lawyer. And I have found that, when you do that, when you approach those cases with empathy, those clients stay with you forever.
Yeah, I agree with you very much, Jeff. And the thing is with immigration law, and there's a lot of aspects of it where one's own sort of fund of knowledge above and apart from just the immigration statutes and regulations. For example, if you're doing asylum cases, your own fund of knowledge about a particular area of the world, or your own innate curiosity about country conditions, your drive to learn about the country conditions, that plays a huge role in magnifying your effectiveness. Likewise, if you're doing business immigration, above and apart from knowing the regulations for an L or an H-1B or an O, your drive to help a business achieve a certain outcome, to optimize its ability to move its staff around, from abroad to the United States, and the strategizing driven by your own curiosity and drive to achieve an outcome. I think that goes a huge way to magnify your effectiveness as an attorney. That's what I would add to it. What do you think about that?
I 100% agree. I think, we're not in a field that's governed by decades of precedent or, established law. In fact, immigration reinvents itself on a daily basis. And so, for that reason, I think oftentimes practitioners who are entering the field are on equal footing with people that have been doing this for decades, because they have that natural curiosity. They have that drive to learn. They understand that they're in a field that's constantly evolving, and so they're not hindered by decades of precedent and institutional knowledge. I think people entering this field can compete equally with practitioners like me who've been doing it since the 1900s.
Right, and the policies change, and the country conditions change. So in some of these areas, the rate of change of circumstances and policies can be quick, and it requires a continuous interest in the subject matter to be motivated to get up to speed and stay on top of these changes.
Yeah, not only an interest, but an obligation, I think. I think, it's really, you can't really practice in the field of immigration law unless you are daily keeping up with what's happening, on the ground, anecdotally, in your service centers, in your field offices, with your clients. And so, that constant information channel and adapting to changes in what's happening in processing is really important. And I think that's where AILA comes in. I think that's where AILA as an association does a very good job keeping members prepared and ready to best represent clients.
And let's talk about what outstanding outcomes would be. So, there can be there can be outcomes, there can be good outcomes, there can be outstanding outcomes. So when you try to think about various aspects of immigration law, and certainly in the business immigration context where you are now, but also in your past work in asylum, how would you differentiate what's a good outcome versus what's an outstanding outcome?
Outcomes to me, especially in the field of immigration law, are somewhat unpredictable, especially if you're doing removal defense, right? Because you can prepare the best case, the best legally argued case, the best evidentially prepared case. But if you have a judge that's not a good judge, then, it is what it is. And so to me, the outcome is one thing. And, obviously you want to strive to get as much success, as many successes for your clients as possible, but also communicating the realistic situation to them, the processing times, how long it's going to take, what kind of hurdles they're going to face, what likely the government is going to argue if they fight back. That communication channel all through the case from the beginning to the end is to me is what really helps you achieve the best outcome. Because even if you don't win, at the end of the day, if you have held your client's hand and communicated effectively with them and really kind of walk them through the process, then even an unsuccessful outcome is still going to be a good outcome for that client, because they're going to feel like you were a partner in the whole process. So I think for me, communication and responsiveness to clients is really what drives positive outcomes with clients. I can tell you that here at BAL, we actually send out an NPS survey to our clients every time we file a case. And So, we're asking them to rate us under an industry standard that, other industries use. And so we're able to track our customer service scores using NPS and kind of compare ourselves to other industry leaders. And so, we can take outcomes very, very seriously and report back to our clients in a tangible way so they can see it.
Well, that's a really interesting approach to it. I mean, certainly setting client expectations is so critical. I mean, you can have, for example, in the removal context, you can have someone who's out of status, and they're in removal proceedings, and you know, getting proceedings closed administratively or getting them deferred action or something like that, while it's not a permanent solution, is for a person in those circumstances is a huge leg up, right? It's much preferable to where they were. So yeah, so I mean, setting expectations and then achieving the maximum possible within the context of the expectations that you're setting. I think that's part of framing what would be outstanding. Would you agree with that?
Absolutely. Yeah.
Yeah.
It's that communication and, the feedback loop to the client so that they're aware of what's happening. They're aware of what the government is doing with their case. And, when there's a decision, they're aware of what that decision means and what the next steps are.
Let's talk about best practices, and I'm sure you have a lot of them. So, can you share some of your best practices with regard to immigration law practice and how those best practices flow into achieving successful outcomes for your clients, especially in more complex cases?
Yeah. So, I mean, again, I think for me, it's really understanding the strategy of the case from the beginning to the end. And sometimes that strategy, is going to pivot, right? You know, this is what's going to happen here, and then this is what we're going to do if that happens. So let me give you an example. Case that I'm reviewing right now on my desk today started out as a very straightforward one step parents of a US citizen case. And we found out about halfway through the case that the parents are actually active members of the Chinese Communist Party. And so obviously that creates a problem for their case because that's something that makes them inadmissible as permanent residents. And so we had to pivot, and we had to sit down with the client and say, this is an issue in your case. And we had to really kind of delve into the details of what that means. And so, what we found out from these clients is that they grew up very, very poor and that the only way to really gain meaningful employment is through education and through jobs. And that is really managed by the government, by the Chinese Communist Party. And so, you kind of have to commit to the Chinese Communist Party to get into school. You have to commit to the Chinese Communist Party to get the best paying jobs and to stay in those jobs and to avoid harassment. And so, the first exception to that ground of ineligibility is if you can show that the membership in the Communist Party was neither voluntary nor meaningful. And, so we're submitting evidence to show that this was required for their job, that they only went to the mandatory meetings. They never participated in party activities. In fact, they espoused democracy. They tried to come to the United States to go to school and were just simply not able to afford it. The great part of this case is they sent their daughter. They raised enough money to send their daughter to the United States, who was educated in the US, joined the US military, and then got her citizenship through the military, through the MAVNI program. So it's a really compelling case of, even though these parents have this wrinkle, they have raised their daughter to be the ultimate demonstration of patriotism and democracy and commitment to the United States. So we're going into this arguing that their membership was neither meaningful nor voluntary. But the truth is they just gave it up before they came to the United States. And so we have some negative factors. And so I have been very communicative with the clients that this argument that this was not voluntary or meaningful may not survive, may not carry the day. And if it doesn't, then the next move is we have to file a waiver. And in order to get that waiver, we have to show that, it's interest of the family unity and humanitarian reasons to get this waiver. And then even if we don't win that waiver, they're going to be put in removal proceedings. But after 5 years, if you haven't been a member of the party for 5 years, then it's no longer a ground of ineligibility. So I have basically walked the clients through, step by step, if this, then this, if this, then this. And so that's an example of like really sitting down with the clients at the very beginning and saying, here's how we could win. And if we don't win, here's the next step. And if we don't win that, here's the next step, so that they really truly understand the trajectory and the timeline for how this is going to take the case forward.
Jeff, I used to do almost the exact same thing. I used to game it out really visually for the clients, the various roadmaps, the roadmap of the case and what the twists and turns could be. And I actually used to portray that visually, either on a piece of paper or on a dry erase board. Here we are, and we're trying to get here, and it could go this way, it could go this way. If it goes this way, then this could happen, that could happen, and so forth. So I think that's it strikes home what you're saying, and it's an very interesting story. So yeah, best practice, definitely outline the roadmap of the case in detail and what all of the twists and turns could be, so that clients know what to expect. Now, how about client relationships in terms of greatness and outstanding outcomes? How important is building strong relationships with the client? You've already talked about the importance of the communication. So are there any other strategies that you use to increase the trust? I mean, maybe some practical things, or just an angle that you take, or a philosophical approach to trust and communication with a view toward building strong relationships.
Yeah, I would say a couple things. I mean, especially in the corporate side, you're building relationships at different levels. So you've got relationships with the foreign nationals who are, moving to the United States or relocating globally. But you also have your relationships to your global mobility managers, the people that are actually managing the immigration programs within these companies. And so you're having regular calls with global mobility professionals to kind of talk about their program, to talk about what's happening with the cases, to talk about how to move the program forward or elevate it, make it better. And so, if you're doing regular calls with these people every other week or once a month, you do create a relationship, you create a friendship with these professionals that you work with. And so, that relationship, that friendship creates the trust, so that you're not being micromanaged at every level, and you're not micromanaging the client at every level. There's a level of trust that we know what we're doing, and we've kind of given each other space to do our roles. But also, if there's a mess up, which is ultimately going to happen, if there's a mistake, there's a level of trust and honesty where you can go back and be vulnerable and admit it and talk about how you're going to fix it, and talk about how you're going to prevent it from happening in the future. That also requires communication and trust. And if you don't have that relationship and trust, and you make a mistake, the client is more likely to move on and go to the next person, the next lawyer. So that trust and that relationship and that honesty and vulnerability, I think, helps cement the relationship going forward.
All right. Well, let's segue just a bit and talk about technological advances. It's huge. It's huge for me because of my role as a co-founder of DocketWise. But in the practice of immigration law, I mean, how do you see legal tech changing the practice from your vantage point? And what tools or innovations do you believe are important for immigration lawyers to use to become successful? So what are your greatest hits in terms of things you really shouldn't be doing without these days?
Yeah, I mean, I will tell you that I've been doing this now since 1997, and I have never seen a more rapid pace of technological change as we have right now. And my son starts law school next week, and I told him, I was like, you need to make sure that you're entering fields of law where human beings are relevant and necessary and can't be replaced by robots. And I think the truth is that a lot of work that we do, the realistic situation is that it's going to be replaced by technology. Filling out forms, a lot of the transactional stuff that we do can be done very easily by technology. And I think your company is doing that. I know my law firm is doing that with our own patented internal technology. The truth is, robots are the way of the future in the legal field. So the question is, what is the role of the lawyer and paralegal in a universe where a lot of our work is going to be done by robots? And I think that's, again, where relationship and communication and strategy and knowledge and empathy, those are the things that can't be replaced by a robot. And so I don't think that lawyers or paralegals are going away, but I do think our roles are going to change significantly. definitely we're going to be, the source of expertise, the source of truth, the source of strategy, the source of empathy and emotion. And so customer service is going to be much, much more important in what we do. And it's going to be much more of a market differentiator than it is now. So, the importance of technology, it's absolutely critical. And I think immigration lawyers especially get really comfortable using, one product, right? They'll stick with one product forever. And there's this fear of advancing or moving or changing technology. And in my opinion, that's a significant weakness. You have to be willing to adapt and grow and change. And, you know, more than I do, I'm sure, about what's next on the horizon. But, I can tell you that even communications right now are being done by robots. If we have enough information in our database that 90% of communication can be done and filtered by a chatbot. So
Yeah, the AI. I mean, the having the AI in terms of the research, its ability to do research on the statutes, the case law, having to worry about shepherdizing cases be a thing of the past. I mean, it is a thing of the past, but I mean, your entire research process and then taking your research findings, synthesizing them and, analogizing them to the fact pattern at hand, and then your document creation, all of that's going to be done with AI.
I do think there's a huge ethical, uh, discussion that sort of surrounds and envelops this issue too, because it's going to be really easy in the future to put something in the computer and say, please draft me a motion on X, Y, or Z, and for AI to pump out the motion. But it is your license on the line when you submit it to court, not the computer's license. And so the ethical issues of making sure that you're doing an argument that is actually legally valid, that has been properly researched and vetted, and that you're not just submitting something that's pumped out from a computer is going to be a huge ethical challenge for lawyers going forward.
Yeah, Jeff, it's something which I've been delving into quite a bit, and I've actually been active in encouraging practitioners to get involved in the evolving ethical discussion, because there are various state bars that have come out with guidelines and best practices on the use of AI. There are some projects underway, like for example, Duke Law School has a Rails initiative, which is Rails standing for Responsible AI Usage in Legal Services, and they have a kind of a tracking database where they are monitoring court by court, standing orders that are coming out. Standing orders are coming out from federal and state courts. They're coming out from federal and state agencies. They're coming out from courts in other countries, and those are compiled in the Rails database. So getting involved in the committees and the task forces that have been set up by the various bar associations and having one's voice heard, because now is the time when the contours of these rules are being hashed out. And we want, as many practitioners as possible to add your voice. Don't leave it just to a few people who are passionate, get involved in it. But certainly that, yeah, what you said, I mean, it implicates a number of existing ethical rules, right? The duty of competence, and among many others, to be competent in using the technology, candor to the tribunal, right? I mean, all of these things are implicated when you're talking about creating a brief, creating a motion or other document that you're going to file with the court or with the government, and making sure that that has been thoroughly checked for its accuracy. All of that's implicated. So it's something we can, I hope that when you are installed as president of AILA, I hope that that's something that you're also going to have a chance to lean into. Certainly AILA is already involved in the debate, but hopefully you will lean into that as well. And, I welcome the chance to get more involved in any initiatives that you might advance during your time as president of AILA.
We would love to have you. You're certainly an expert in the field, and so that's definitely something that I would love to rely on you for.
Yeah, I'm looking forward to it. Absolutely. Let's talk a little bit about let's extend our discussion of the ethics. And so, Jeff, for you as a practitioner, how would you describe your ethical mindset as it pertains to law practice? And how does that contribute to your ability to be a great immigration lawyer and achieve outstanding outcomes? How do you go about keeping the ethical principles in mind?
Yeah, I mean, I think the good news about the law profession is that ethics is not optional, right? I mean, it is something that we all, in order to keep our licenses, we have to keep up with the rules of professional conduct. We are under every state has specific rules that you have to follow regarding professional conduct. And if you don't follow those rules, anyone, client, other lawyers, the courts, the judges, can sanction you for not following those rules, and you can use your license. So, in the field of immigration, especially, I think when you're dealing with really super vulnerable populations that a lot of them don't understand the U.S. legal system. They're used to operating in legal systems that are very, very different than ours, that often involve bribery, corruption, et cetera, et cetera. It is super important that you stay above the board with everything you do, that you make honest representations to the court, that you make sure that your clients are constantly telling the truth. There's a lot of fraud in immigration applications, and I have found it in my own cases. And it's important that you understand a what happens if you discover fraud, b what to do about it, what your obligations are if you discover it, and c how to handle it with the client. And so things like that, things like dual representation. A lot of cases in immigration require you to represent two different parties, a husband and a wife petitioner and beneficiary, or a company and a foreign national employee. And oftentimes those can create very tricky ethical situations. If you are representing a couple that is going forward on a marriage petition and suddenly that marriage becomes abusive, you have a conflict of interest. You can no longer effectively represent one party because doing so may implicate at the expense of the other. And so those are the kind of situations you constantly have to be attuned to and aware of and know what to do if that comes up in the practice. Same thing on the employment side. I have all the time, I have employees that call me and say, I got a job offer from another employer. What do I do? Well, I don't just represent you. I also represent the employer that you're thinking about jumping ship from. And so, those kind of discussions become very, very tricky ethically, and how you handle them are governed by principles of professional conduct that you kind of have to follow. So it's not optional. It's something we all need to be aware of. And it's something that's also constantly evolving. We mentioned AI and the world of AI. That really turns the rules of ethics upside down when it comes to what we file in court and the representations we make, because it's no longer our product. It's a product that's being produced by computers. So you're still responsible for it from a professional conduct standpoint.
It's what elevates the profession above any other purely transactional business is the ethical canon. Um, you can't just. Certainly, you can be aggressive in your marketing, but you can't just be a salesman. The ethical guidelines have to be kept in mind from all of your, with regard to your advertising, with regard to all of your contacts with the clients, all the way through, even after representation of the client in terms of maintaining confidentiality. So embrace it as what I'm driving at. I'm saying embrace it. Embrace the fact that there's an ethical canon and that it is something that makes the profession more noble. It elevates it above just a purely business activity. And it is it underlines, and it is an integral aspect of why the legal profession and the legal system is fundamental to a democratic society, a healthy society, a society governed by the rule of law, right? Not whims of particular leaders or powerful or influential people. So embrace that, because you as an individual lawyer embracing the ethical canon strengthens the profession, which in turn strengthens the legal system and makes the quality of life in the society better. That's what I say.
Yeah, and the other thing I would say is, we're about to hit 18,000 members in AILA, immigration lawyers around the country, which sounds like a lot of people, but it's actually not. It's actually a very, very small bar association compared to the criminal defense bar, the trial lawyers bar. And so, the size of our bar makes ethics very, very important because if you establish yourself as a distrustful lawyer or a dishonest lawyer, that reputation is going to follow you very, very quickly. And the same if you establish yourself as an ethical, principled lawyer, that is also going to establish a reputation very, very quickly. And so, in a bar like ours, it's really easy to establish yourself as one of the best because it's a small bar, and it's also really easy to ruin your reputation. So it's not optional. Ethics, like you said, is it elevates the practice. It's something we should aspire to, and it makes us all better. It really makes the profession
It does indeed. Well, Jeff, you have to be persistent to be a great lawyer, that's for sure. So let's talk about handling adversity and or how do you handle situations where you have a case that's perhaps high stakes or where the potential negative consequence to the client is very impactful, potentially devastating even in some cases, and you get an adverse decision. How do you approach dealing with that with the client?
well, I mean, they happen, right? I mean, we all get adverse decisions. The hope is that when you get an adverse decision, that there's some remedy. And so, one of the things that I've made a part of my portfolio for my clients is federal court. So, oftentimes when you're dealing with the agency, you get adverse decisions because those adjudicators are not lawyers. They're often contract adjudicators. They're may or may not be highly sophisticated in the petition. So you're going to get decisions, but most often there's a remedy. There's an appellate remedy either in the agency or if there's not an appellate remedy with the agency, there's often the opportunity to go outside of the agency and go to federal court. And the federal court is independent of immigration, right? They're judges that are appointed to do all kinds of cases, one of which may be a civil immigration case. And so when we get adverse decisions, we're pretty aggressive about going to federal court to challenge them if we think that the agency, ignored evidence in the record or their decision is contrary to previous decisions that we've received. We will aggressively go to court, and I would say we've had a very, very good success rate getting agency decisions overturned when they ignore evidence or make a decision that's arbitrary and capricious. So we're pretty aggressive about fighting denials and have had good success in federal court with that.
Well, certainly, you have to be persistent. And do you believe that having a very high degree of persistence is a prerequisite to being a great immigration lawyer?
I do because if you can't handle adversity and you're not resilient to backlogs and timelines and client disappointment and adverse decisions, this is definitely the wrong field for you. And oftentimes that's politically driven, right? So depending on the administration in power, things get more difficult or easier to do. So right now we see, in this administration, we see, things like deference to prior decisions. So if you've received a prior approval of a case, there's deference to that case. In previous administrations, that the deference didn't exist. So it didn't matter if you had a previous approval; there was no deference to that approval in a subsequent application. And so, even the policy of the administration can, in many ways, determine the outcomes and the ways that we have to fight the case. So, depending on what happens with our upcoming elections, I think immigration could get much more challenging than it is now.
I'm of the opinion that the best immigration lawyers and the best lawyers in general are those who are willing to pursue all available remedies to their ends. I mean, even if it's a glimmer of hope, the one never knows really until the decision is rendered. Whether one is going to succeed or not. So sometimes there might be a glimmer of hope. You may get an adverse decision. There may be a basis for a non if it's a non frivolous, genuine basis for an appeal, even if the chance of success is low. If there's an argument to be made, if there's some argument or evidence to be put forward, and there's no practical countervailing consideration. In other words, the costs or whatever, the client can meet the costs of going ahead and filing an appeal, filing a motion to reopen, you have to be willing to fight for those glimmers of hope. That distinguishes being great from being just ordinary, in my opinion.
Absolutely. And I think if it's a civil rights issue, which oftentimes we see in immigration, things that actually become a civil rights issue. The example now is the enormous backlog of Afghan parole cases. There's 40,000 cases in the backlog, and it takes several years to get approved. At that point, that becomes a civil rights issue. And even if you don't have a really strong case to take to court, there's a compelling civil rights reason to do it, because it forces awareness and visibility over something that should not be happening. And some of the best cases in history have come out not because there was an amazing legal theory or it was a slam dunk case, but because it was something that needed to be fought. And I think we definitely see that in immigration. And I am happy to take cases, to court that even if I don't think there's a strong chance to win, it's the right thing to do because it's a civil rights
Well, let me ask you this question, what are your thoughts on the current state of the federal judiciary in terms of its receptiveness to immigration cases, maybe both at the Supreme Court level and at the other levels of the federal court system? I mean, do you think that the general, let's say, rightward uh, drift of the courts in recent years, especially at the Supreme Court, but we've had let's say the first Trump administration had quite an opportunity to install a large number of federal judges.
Yeah.
What's your overall appraisal of the climate in the courts regarding immigration?
That's a really interesting question. So here's how I would answer it on several levels. I would say, first, one of the things that we often do in immigration is what we call a writ of mandamus, which is when the agency is significantly delaying cases, you can go to court and say this delay is unreasonable. I would say the courts are much more hesitant to grant those cases than they were in the past. The agency is given a lot of leeway to determine the pace of adjudication. And so we have seen the courts fight back on delays of even 3 and 4 years where cases have been pending. So that's the first thing I would say is that part of the practice has become much more challenging, the writ of mandamus. In terms of the Supreme Court, though, it's a mixed bag because the Supreme Court, the conservative Supreme Court justices, when we say that they're conservative, what they're conservative about is their own judicial power. They're conservative about their ability to maintain control over things. And so when Trump appointed conservative justices, the result was they fight back against his overreach. They fight back against government overreach because they want to conserve judicial power to review administrative decisions. And so this Supreme Court, and I think the more conservative this court gets, the more we're going to see them pushing back on executive overreach and the agency doing things without legislation. On the other hand, a lot of immigration decisions are discretionary. Adjustment of status, for example, getting a green card. At the end of the day, even if you prove all the legal requirements, there's still a discretionary component to adjustment of status. And we've seen the Supreme Court and other courts really push back on challenging discretionary decisions. So there's almost no judicial review of discretionary decisions anymore. Unless you can frame it as a legal decision, you're really not going to get judicial review. And it becomes a gateway issue, right? If adjustment is ultimately discretionary, then it becomes very hard to even get in the door to federal court to get the court to assume jurisdiction over the case. So it's a mixed bag for me. I think, in terms of fighting back at the agency at the Supreme Court level, I think that's going to be easier to do because of the judges are going to be pushing it back against executive overreach. But when it comes to things like discretionary determinations, it's going to be much harder to go into court. And same as delays.
Now, how about the demise of Chevron deference? I mean, what's your appraisal at this point, and where it's just happened recently? Your appraisal as to how that's likely to play out, and what do you foresee as some of the major ramifications on immigration decisions?
Yeah, so the Loper-Bright case, which finally overruled Chevron, is kind of exhibit A of what I'm talking about in terms of conserving judicial power, because essentially the whole point of Loper-Bright is the agencies know we're not going to defer to the agency any longer if there's something that's confusing in the statute or unclear in the statute. The courts are going to make a determination on their own now, and they're not going to defer to agency interpretation. And that's conserving judicial power. So I love it from an immigration standpoint because the cases that we ultimately end up having to fight in court are those cases where ultimately the courts have deferred to agency interpretations.
Yeah, there's something to be said for agency expertise, though.
That's what I was going to say. That's where I was going with this. Is we like to see ourselves as the expert in immigration, but if we shifted agencies and made this about the EPA, for example, that's an area where we really want the EPA to be the agencies that's
Right.
deferred to in matters of determining what's good for the environment, right? So whether or not Chevron going away is good, I think depends on whether you like the agency and the work that they're doing at that moment. So it's sort of politically driven, just like everything else.
You've really captured it. You've kind of you've captured, I think, the right framing of it. Is I had such intense mixed feelings about the demise of Chevron deference. You know, on the one hand, right, there are issues, there are agencies, and there are fields where the decisions that have to be made are of such a technical nature. Like you mentioned, the EPA, the Food and Drug Administration, some of these other areas that involve deep scientific and technical expertise that the judges simply don't have, and they can't, practically speaking, get up to a level of expertise necessary to really kind of take into consideration everything that should be taken into consideration when rendering a decision. That is my view of it. And in those instances, I think that the deference to the agency, which has the in-house PhDs, has the people with the PhDs in biology, pharmacology, all those things, are in a better position to make the rules and make the decisions, and the judges can defer to that. On the other hand, like immigration is not one of those areas. And immigration, it's oftentimes we're just rubber stamping what the agency did, and the agency may not have given the issue that much thought, really, because of the exigencies of running the agency, or because of political considerations within the agency, and sort of subjective policy determinations that are, sort of top down. Here's how we're going to handle this issue. May not have been, may not have been a policy which was the most just policy in the first place, and those were being rubber stamped by the courts. So, Chevron deference was maybe too broad of a framework, or too a framework which lacked nuance. A better framework that incorporated more nuance would have said, we'll defer to the agency when it's matters of particular types of technical expertise, and we won't defer to it when it's not. But that's not what we have right now. We're back to a sort of maximalist, maybe that's not the right word, but more of a conservative, as you said, conserving judicial power rather than giving any of it away to the executive branch agencies. My concern is that the conservative framework will become what I just started saying, which is a maximalist framework. That's, I think, where we get into problems. So I wonder, and I don't know the answer, but I wonder if any thinkers, legal thinkers, have really come out with a framework that is more nuanced to really look across the various agencies and say, well, in this instance, we should have deference. In this instance, we should not have deference. I wonder if there are any theoretical frameworks that have come out that, one could advocate for. Maybe
Well, we still have Skidmore deference, right? So Skidmore is still good law, and Skidmore is sort of like Chevron once removed. And so, the idea with Skidmore is we will defer to the agency if it's a matter over which the agency has particular expertise, is one of the factors in Skidmore, or it's an issue on which the agency has a history of pronouncement that is consistent. In other words, they've taken the same consistent position historically. They're more likely to get deference. Or if it's a published opinion, relying on a published opinion from the agency, that it's more likely to get deference. So that framework, where there are certain circumstances where we will defer to the agency, still exists. So I think what's left open to see is whether, okay, Chevron goes away. We're not going to automatically defer to agencies any longer, but in particular instances, we may defer to the agency, and here's those instances where we would do that. That's the Skidmore framework.
So the foundation of what I'm talking about is there. I guess what has to be done now is really advocate when trying cases, really advocate for particular interpretations of the Skidmore framework and whether an agency does have the expertise that's mentioned in Skidmore. So it's a question of building up the foundation in Skidmore by trying more and more cases where precedents can be set and where doctrine can evolve in a way that creates a framework, a more developed framework out of Skidmore. Now that depends on people being willing to try those cases and make those strong arguments to help, you know, develop that framework and make it evolve into doctrine. Also depends on who the judges are and whether they're going to allow that to happen. But yeah, I'm glad that you sort of elucidated that about Skidmore. I mean, I have my concerns. I mean, I want to make sure we're talking about air and water and food, air and water quality, food safety, that we have, the
Yes.
most drug safety, that we really
Yeah.
do have actual science people,
Experts.
make experts making those decisions. Yeah. Okay. Well, we've kind of beat that one a little bit. Let's talk about let's talk about mentorship and collaboration. So mentorship is really important in becoming an outstanding lawyer, an outstanding immigration lawyer. So how important has mentorship, both early on receiving it and now later at the stage that you're at providing mentorship, been to you as a great immigration lawyer?
Well, I think it's 100% critical. I think a one of the things that I think is one of the most important parts of my job as an incoming AILA president is to identify and recognize and promote good talent in our organization. I mentioned the size of our organization is 17,900. That being said, it still very much feels small. When you go to an AILA conference, you run into people in the halls everywhere that you know. And so one of the challenges, I think, is continuing to recognize and bring up new talent, because I'm old and I'm exiting my career at this point, and we need new AILA lawyers to come in and take in the reins and take the organization and the practice of law forward. And so mentorship to me is really critical to the future of what we do. And so I can say that personally, I had amazing mentors that recognized particular talents that I had and encouraged me to speak at AILA conferences. I happened to be, before I went into the practice of law, I clerked for the public defender's office, so I had some expertise in criminal defense and trial. And that shortly before I graduated in 1996 is when President Clinton passed IRA, which sort of exploded the criminal grounds of deportation and inadmissibility. And so I was immediately identified by my mentors as an expert in immigration, the intersection of criminal and immigration, and was asked to speak locally and nationally on the criminal implications of immigration. And that recognition and that promotion of talent is really what elevated me to leadership in AILA. From there, I was encouraged to run for my chapter, the Colorado chapter, as an officer, and then ultimately for the board of governors, and now I'm obviously on the executive committee. But without that identification of talent and that mentorship and that encouragement to actually do my, hone my skills and promote them, I wouldn't be where I am. So to me, it's looking back at those mentors and appreciating where they've gotten me, and then in turn paying it forward and mentoring other lawyers and recognizing their talents is also really, really important. And I would say that in the world of the law, you're not just a one trick pony, right? There are some people that really love trial law. There are others that really love government liaison. There are others that really like well-being. Whatever your passion is, whatever you have to contribute, do it. Bring it to the table, because our association has a big enough tent to recognize all talents and promote all talents. And so I encourage people all the time to reach out to me and tell me, here's what I bring to the table and how I'd love to get involved. And I promise you that I will find a way to get you involved in the organization.
Fantastic. And that's a great segue into what I wanted to ask you next. So if we can zoom out a little bit, and you're the president-elect of AILA, and as we said, you'll be installed in June. Can you give us a sneak peek as to what your primary goals and vision for the organization will be once you are installed?
Yes, with a caveat. I'm going to put a big caveat on this because it depends entirely on what happens November 4th.
Sure.
You know, if we have a Trump administration, my entire presidency is going to be devoted to fighting back against that administration, opposing that administration, and all that they do to restrict legal immigration.
And how do you plan to do
So
that?
um, we're going to go to court. During the last administration, I'm proud to say that I filed 12 different class action lawsuits against the Trump administration. I was successful on every single one of them. It was the time when there were travel bans around the country, and the president was interpreting the statute to give him authority to shut down visa processing at consulates around the world. And we knew that that was wrong. That's not what the statute said. And we challenged it. And we went to court in DC and filed a number of class action lawsuits that got those consulates reopened and processing visas again. And that's exactly what I intend to do if Trump's elected again, is we're not going to sit by for 4 years and let him destroy the legal immigration system. We will go to court and we'll aggressively challenge every restriction on legal immigration that he puts in place. If Trump's not elected, then I would say that I'm going to focus internally at AILA, because to me it's an amazing organization, and we're kind of at a pivotal point where we've talked about technology, we've talked about membership, and I think the future of AILA is really, really bright. And so I would be focusing internally on our committee structure, our governance structure, the way that we're organized to try and move the organization forward and make it better. So it's either going to be an external focus or an internal focus. It entirely depends on Trump.
How would you plan to increase member engagement in AILA?
Great question. I think part of it is new talent. We are blessed with really, really amazing lawyers who are very, very dedicated to the practice of law and continue to be dedicated. But the problem is that when you rely on the same pool of talent to speak and to be on committees and to do government liaison work, then you're not fostering new talent. And so for me, there's a lot of reasons from both a DEI perspective, but also just the future of our organization perspective to get new people in the pipeline on committees, doing liaison work, speaking at conferences. So, for me, member engagement is first about recognizing, promoting, and bringing in new talent. And then it's about creating community, a sense of community. I think people don't just want to come to AILA to learn. They want to feel like they're part of a community of people that understand what they do. Immigration law is not easy to do every day. And being around people who understand the complexity of what we do and the emotions involved in what we do is really, really important. And so building that sense of community, allowing people to find friendships and partnerships and colleagues that share common interests is really, really important. And so, this may sound silly and trivial, but AILA just approved a special interest group for Bravo fans, people that love to watch Bravo reality TV. And that may sound trivial, but it was interesting. At the annual conference, they had a happy hour. It was extremely well attended. And, and there's a whole community around it. And so we're looking outside in AILA and saying, whatever you want to do, whatever interests you, bring it to the table and we'll make it happen for you. So really just trying to create community and engagement.
So how about with legislative and policy advocacy? Not we talked about, if Trump wins, you're going to engage in litigation. We said that. But in terms of advocacy, so what are your thoughts on AILA's role in shaping immigration policy, and how would you strengthen that during your tenure as president? Maybe you want to talk about, what you would do differently if Trump got elected versus if Harris gets elected.
Sure. So the Board of Governors last year authorized AILA to get involved in political engagement. And so for the first time in history, we created a committee on political engagement. Its primary job is to really get local AILA members involved in local politics, either by running for office or by promoting candidates locally. And our organization, the legal structure of our organization, does allow us to sponsor and promote candidates. And so we created a political engagement committee that's going to take a really active role next year in promoting local races where candidates support comprehensive immigration reform and reform that makes sense. It's the first time we've done that because there's always been a hesitancy to support candidates on one issue when we may not support them on other issues, right? So Republicans, for example, may be really, really good on immigration, but not good on other issues that we're passionate about. And so we decided to basically create a strategy where we make it about immigration. We're going to support a candidate. We're really just looking at their immigration record, and we're sort of not paying attention to other issues that maybe other members, the members may be passionate about. And so, political engagement is going to definitely be on the uptick. The other thing that we have in AILA is we have Immigrants List, which is a partner organization that is basically a lobbying organization for pro-immigrant candidates. And so Immigrants List is really formalizing the relationship with AILA, and we've done a lot of work to support pro-immigrant candidates in this year and this election cycle and in past elections.
And Jeff, as you approach getting installed as the president of AILA, how will you balance your roles as a partner at Barry Appleman and Layden versus your work with AILA? I mean, will you continue to have a full docket of cases at the firm, or if you don't mind my asking?
Yeah, I mean, I would say, Barry Appleman Leiden has been incredibly supportive of the work that I'm doing in AILA. And the Leiden part of Barry Appleman Leiden is a former AILA president. And so the firm has a history of leadership in AILA, and they understand what it means to be president of AILA, and they've been unbelievably supportive. I also think that there's obvious collateral advantages to the law firm of having somebody in leadership. I definitely have my pulse on what's happening in the government, and so there's definitely advantages to the firm as well. As far as time management, it does get a little tricky. I'll be honest with you, because this year and next year become very, very busy for me as president elect and president, and so it's a matter more of just really organizing my time. I definitely have carve outs for my AILA time and carve outs for work, and I have to be really disciplined about making that happen. But so far, it hasn't been a problem, and I can say that there are a number of AILA presidents who didn't work for big firms, that were really sole practitioners, and they were able to make it happen. And so, if the sole practitioner can make it happen, I know that I can make it happen with.
Let's just talk about legacy. So, when all is said and done, I mean, have you given any thought to like what is the legacy that you want to leave in the field of immigration law? I guess it's probably an evolving question because you're going to be, regardless of which candidate wins, it's going to be a very momentous tenure that you have because of the importance of immigration as a political issue right now in the United States. Now, if Trump gets elected, you're going to be in such a hot seat that you have you're going to have the opportunity to be so high profile and have such an impact, I believe. And you still could if Harris gets elected, but in a different way. But anyway, have you given any thought to like what's the legacy that you see yourself leaving in the field of immigration law?
Yeah, I mean, I would say if I want to leave a legacy, it's going to be in federal litigation. It's something I've always been passionate about. It's something I've always done since the beginning of my career. And for me, it's a way to really change the law, to change the trajectory of what's happening, and change the law. And so for me, if Trump gets elected, I want my legacy to be that when people look back to say that Jeff Joseph really fought this administration as hard as he could on behalf of our organization and was victorious in fighting back on illegal activities and restrictionist activities. And so for me, it would be really that I represented members well, and that they are they are appreciative of the work that I did to fight back against the administration. If Harris gets elected, then it's more about cementing the relationships that we've created the past 4 years. for the first time in really AILA's history, we have insiders at the White House. We have former AILA staffers that work in the White House. We have former AILA staffers that are in the highest levels of committees in Congress, and so we really have cemented really good relationships and have been able to do a lot of really good work in liaison over the past 4 years. And so, if Harris gets elected, then I would love my legacy to be that we really created relationships with the government that are eternal and lasting.
Wonderful. Let's hope that that happens for the good of the immigration bar, and we're going to think positively. And we only have a few months left, and things are looking up, right? Things are looking up. But that is all the time that we have today, and it's been really a fascinating discussion with Jeff Joseph, who is a partner at Berry Appleman and Layden, based in Denver, Colorado, and Jeff is the AILA president-elect. He'll be installed as the new president in June 2025. And this is James Pittman with Immigration Uncovered. So please join us again next time for our next episode. And Jeff, thank you very, very much for joining us and for your time today.
It was super fun. Thanks for doing it, James.